welcome to the Melinda Eitzen Show. I'm Melinda. We're so lucky today to have Natalie Gregg with us. She's also a family lawyer, and we're going to talk about process choices to get divorced. Welcome, Natalie.
Hello, how are you?
Great. I'm so glad you're here. Thank you for coming.
Thank you so much for having me.
So, we're both family lawyers. We've been fortunate to work together in the past on cases, either on each side or mediated some for you. So, I know you're good.
Oh, thank you. And likewise, you're a very skilled mediator.
Oh, thank you. So, we both have experienced people coming in and talking about, hey, how do I get divorced? And there's different process choices, right?
Absolutely.
So, what are the process choices?
So we can go as simple as, hey, let's get around a table like this, a kitchen table, and a couple can decide what they want to do with assets. They can outline basic things that are their goals. We call that a kitchen table. That is the most basic. Then we can actually engage in litigation. Litigation, as both of us know, can be very costly, but sometimes it's absolutely necessary.
And it's the default model, right?
Yes.
That's
So-
what happens if we can't agree on another process choice.
Exactly. So litigation is the default, and that involves going to court, presenting in front of a judge, having evidence. And a lot of people say, I want my day in court. And I say, be careful what you ask for, because sometimes that day in court can be weeks in court, and it can be years sometimes to get a divorce.
And very expensive.
Yes, ma'am.
I would argue the most expensive process choice.
I would too. And I think I was sharing earlier with you that my experience, so I'm collaboratively trained, I'm a trained mediator, and I'm also a litigator. I would always, if possible, tell people to think outside of the box. Don't listen to your rah-rah friends who are saying, oh, we're going to get him, because sometimes that can be very toxic.
Mm-hmm. Okay, so we've talked about kitchen table deal, litigation. What's the next one?
So there's a process, as you are familiar and trained and really good at, collaborative law. And that is where you completely opt out. You say, in an actual formal process, we're going to opt out of litigation. We're going to agree. We're never going to see the inside of a courtroom unless there's a very small exception for family violence. And it's a process that involves control and a team model with everyone involved in a confidential setting.
And people get a little confused about collaborative because that's such a common vocabulary word. But when we say collaborative, we're not just talking about let's all get along.
Right. We're not talking about kumbaya high fives. We're actually talking about, there's a codified section of the Texas Family Code where it defines what collaborative law is. So you, once again, you sign that participation agreement. It gets, signed by all parties involved. Then we file a notice with the court to get off the dismissal docket so that they're not up in our business. This is important because of the privacy. A lot of times you have couples who have embarrassing facts, or you have children that have very special needs. And if you go into a courtroom, a judge is just going to rubber stamp what the typical schedule might be, the standard possession schedule, or they might just not have time to hear all the nuances of what's going on with this family.
So a lot of people also think that mediation is a process choice. And they'll call me as the mediator and say, hey, we want to hire you to be our mediator. I'm like, go get a lawyer and then hire me. I can do it pro se, but it's not ideal. But how does mediation fit into all this?
So I like to draw a timeline for my clients and say, we start with the petition for divorce. Then you either have temporary orders or a temporary interim agreement. So that's where we agree on child support, custody, the rights and duties temporarily, and any other property issues that need to be addressed on an as needed basis. So after we have that temporary agreement or temporary orders, then we do discovery, and discovery is a process that involves exchange of, as you know, financial information, information about medical conditions, witnesses, but mainly the finance part is the big portion that we need to get to mediation. And a lot of clients don't understand within that process, if we don't have all the information, we can't divide a pie we don't even know what it's comprised of.
Right, right. And then mediation occurs.
Yes, and once again, as the rock star mediator that you are, mediation is, it's a day-long process. I always tell clients to wear comfy clothes. No one cares what you look like.
Right.
Bring all your devices that you need to communicate, and hopefully that's our day. I think the statistics are 95% of cases settle outside of court. I seem to get a lot of clients that don't want to settle, or I think maybe they come to us because they have tried everything.
Yes.
And
yes.
sometimes you can try everything.
Yes.
You can go to mediation in good faith. You can have all the information in front of you and still not feel like you're ready to sign on the dotted line. And when a client says, I don't feel ready, I feel coerced, I feel scared, of course, we're not going to let them sign. But the happy, good thing about mediation is if you do, it's all over. And so from there, we turn that into the mediated settlement agreement goes into a final decree, and you never have to see a judge again, aside from maybe approve up a final hearing.
So mediation is a tool that can be used in either litigation or in collaboration.
Yes. And oftentimes we use mediation when we come to a loggerhead in collaborative, because going back to that process, that is a series of joint sessions that are, a lot of people, there's a misnomer. They think those are little mediations, but they're not. It's a 2-hour session with a team of a financial neutral, a mental health neutral, both clients and both attorneys. And in that process, we'll come to a bunch of agreements, and then sometimes at the end there'll be just maybe a question about how does the business get divided, because it's not as simple as chainsawing it or even giving shares.
So the other thing people ask about is arbitration.
So arbitration in my practice is not very often used.
I agree. That's true all across the family law world.
I've heard in other states that it's very successful, and that there's even like Zoom arbitration where they do entire dockets online in other states.
Interesting. So what is it?
So arbitration is like a mini trial. It's more formal than mediation because there is evidence that's presented, and that finder of fact, the arbitrator, actually listens and makes a ruling as if almost like a judge.
Problem with my viewpoint, problem with arbitration is you're waiving your right to appeal.
I think it's a huge problem.
Yeah. And I think that's why we don't like it.
Well, and when you have such high stakes determinations, the client definitely wants to know, what do I do if this doesn't go my way?
Yes. I think that's why it's not popular here, is that problem. But you're right. It hardly used. You barely ever hear anyone using it. And if you do hear of it being used, it's for something minor, like arbitrating a disagreement about what was in the mediated settlement agreement. What did it mean, or something like that?
We have arbitrated divisions of like a wine collection, an art collection, things that people might think are trivial.
Furniture.
Yeah.
I kid you not, Christmas ornaments.
And this is our life, right? Melinda, I once had a hearing where the judge called me and opposing counsel down because we were arguing over tools. And I advised my client prior to this hearing, I said, I can just take you to Home Depot for what you're going to get me for attorney's fees. And the judge just looked at us and she's like, can we all just like stop right now? Because we are wasting everyone's time.
Yes. Although my husband would argue tools are important.
I think everyone has their special thing that has value.
Yes. Okay, so we've identified the processes. We have kitchen table deal, litigation, the default model, collaboration. Mediation's not really its own process, it's a tool used in one of those processes. And arbitration's really not a thing here, so we don't need to focus on that very much.
Sure.
So there's pros and cons, wouldn't you say, to each one?
Absolutely. So with litigation, one of the pros is that you do get access to the court, and you have a date, and you know, at least theoretically, right? Because we know there are continuances and there are delays sometimes, but you have, okay, I have a trial date, and I'm gonna be divorced, or I'm gonna know, if I have custody at this point in time.
Yeah, it feels a little bit more deadline-ish. I will agree. I mean, I'll tell you my bias before I talk about that. My bias is collaborative in most cases, and that usually litigation is because one side is crazy. Like they cannot sit down and make a decision because of their psychological condition. And so you have to try those cases, and some just have to be tried, and we're happy to do it. But I lean towards collaborative. But I will say one of my frustrations, and it just happened on a case, is some of the other lawyers on the, handling the collaborative case on the other side, because it's still two lawyers, right? One represents the, one spouse. They don't always prioritize their collaborative case, and I can't get the decree entered. I cannot get the decree from them. They will not take the time. And in one, we even said, I was trying to avoid this. So I said, can we all agree on a signing meeting? I was trying to create a deadline. Let's have a signing meeting that we're all going to agree the clients are going to come sign the decree. And so then we have to back up from that and say, when are you going to get the decree to me, or I'm going to get it to you? And then when are you going to get your changes? The day before the signing meeting, she gave me the first draft of the decree. So I canceled the signing meeting. I can't read it in 24 hours.
No.
And I have to be able to give her my edits. We have to give it to the team to review. The two neutrals you talked about, the financial neutral, the mental health, we all have to agree on the form of that before it goes to the clients, and then they have to have time to review it. It was a 65-page document.
Well, and I think it also makes us as attorneys look bad when you're trying to not throw the other attorney under the bus.
Yes.
Because you wanted to probably say, well, I just got it last night.
Oh, I know. Then her client was furious and was writing and saying, can't we just have the meeting anyway and talk about the timeline? And I was like, look, I can't talk about the timeline. I already tried to create a timeline.
Well, and it would have wasted however many professional at the table by the hour, just sitting there twiddling
for no
their thumbs.
reason. Right. So I think that is a negative of collaborative. Now, I would still say it still wins the day over litigation 90% of the time. And not every case do you have the other lawyer not cooperating. And probably she doesn't do that in every case. She had a life circumstance. We all have life circumstances. We're humans, come up. So it probably was just one time, and it was just my bad luck that I'm the case that...
Yes.
But that is a negative, I would say.
I think another con of collaborative is you can't tell your client everything that the team's talking about. So when you did have this incident with your colleague, your co-counsel, you can't say, this is just what happened. And then so there's kind of some blame shifting, I think, sometimes. But generally speaking, at the end of the day, I find that the results, so the parenting plans are amazing.
So much better.
They're so custom. There's so much thought. As a parent, that's what I would want as a product. And then also the financial settlement, you have so much detail. It's real time updated. And as lawyers, it feels really good to have this person who that is their job, and they're the expert on that.
The neutral.
And we're, the financial neutral. And we're here to advocate and to say what pieces to move, but we're not in control of the data collection and maintenance.
Yes. So on the collaborative comparison, like you're saying, to litigation, the judges, we have some good judges, some bad judges, right? Just like there's some good lawyers and bad lawyers. But even the best judge, you're like your favorite judge that you'd want to be in front of, they have limitations on what they're allowed to do under the law.
Correct. And they're also, so a lot of people say, well, I have this great schedule. I have a firefighter schedule, or I have this, fill in the blank schedule, custom under 3 that I read this article about, and I want to use it. We can suggest it. We can say that this is, we can even bring an expert in and say this is recommended. This is in the best interest of the child. But the judge, if they deviate from standard possession, expanded standard, what the code says, they're exposing themselves to appeal. And
they do not like to be overturned.
No, and we're in election year this year, especially in Collin County, and I'm noticing that the rulings are very rigid.
By the book. So you hear sometimes people call it a cookie cutter, that you might get a cookie cutter result from litigation, and that's the huge advantage of collaboration, like you talked about.
100%.
It can be custom.
And a lot of clients will come in and they'll say, I have an 18-year-old or 3 kids over the age of 18, and I want to provide for college and cards and insurance and cell phones and all of this stuff. And in litigation, that's not happening, right?
That's a big fat zero.
Like, sorry. But in collaborative, you can put whatever you want to in your final decree. As long as it's not against public policy.
Yes.
So I just finished a case, and my client is so incredibly happy. I mean, she's mourning the loss of her marriage.
Yes.
But, she's very happy with the results. And she's also happy. I mean, she was a nervous wreck during the process, even privately.
Mm-hmm.
And because of COVID, we did it, hybrid Zoom.
Mm-hmm.
But, very pleased, and I'm happy for her because she's come out the other side.
Yes, it helps to move forward if you have a result that you're not angry about, right? People can really live in anger if they get a result from the judge that doesn't make sense to them. They think the judge just didn't hear everything, and there's limitations on what the judge can hear because of the rules of evidence.
I find too that with litigation, sometimes it becomes our client's identity. And so they're living for the fight, and they're sending emails at all hours of the night. Well, we can get her this way or get him this way. And
that sounds like the psychological disorder I mentioned.
Yes. You're like, man, that's a lot of energy that you're spending hating that other person or living in the conflict is what I call it.
Yes.
And when you're living in the conflict, which litigation, unfortunately, you walk in the courtroom and everyone's kind of sitting there like this and waiting for their turn to, be cross-examined on the stand.
Yes. Now, we mentioned a process, the kitchen table deal, but we didn't really talk about it much. So I always tell clients, look, you and your spouse can sit at your kitchen table without lawyers and strike the deal. But usually that isn't what people do.
It's not, and I highly do not recommend it. You told me to look at, I do not recommend that. Getting a lawyer, I mean, and this is not just because I'm a lawyer. I would say anyone. It's, don't necessarily have to hire the best lawyer or the most expensive, but having an advocate in your corner is really necessary. The terms that go into an original petition for divorce or for modification, those are not words that are common. And I have a lot of clients who will come in and they read it online on Google. And they're like, and my mom's group, the Plano moms or the McKinney moms, like they all said that this is what happens.
Oh dear. Well, the problem with the kitchen table deal, you've identified that one, they don't know everything they need to agree to, right? So they need a lawyer to explain, hey, you all have to make decisions about XYZ about your kids, XYZ about your property. And they maybe have had a pattern in their marriage where one person overreaches.
There's always a power inequity, as I see it. And so even when I do informal settlement conferences, you can see the dynamics. I mean, they'll start correcting each other. But getting back to why you need an attorney, some of the things that people ask, well, we've agreed that I'm going to stay on his health insurance until I'm 85.
Not
I'm like,
allowed.
you can't do that. Sorry. And that's just the law, right?
Right.
Or we've agreed that if he ever loses his job, that he'll keep paying $5,000 a month in child support. That's really not
Yeah.
going to happen. I mean, he's going to come back and try to modify.
They don't know what they don't know, that some things are modifiable no matter what you say, because it's in the public policy, the interest of the public, that we not allow someone to say, even if I become an axe murderer, I'm going to be the primary parent, right?
Exactly.
We're going to protect children over contract law.
Exactly. And then I also encourage clients when they start is to contemplate, yes, you might have an 18-month-old baby, but this is hopefully a document that can last you, and we're not going to be in court every 2 years trying to change it. So let's think about all of the options, the different phases of life, and then also, employment. Right now the economy is, kind of a hot button. Not everyone, not like Oprah, you get a house and you get a house. Like that used to be when I first started practicing 20 years ago. Everyone, we'd get enough money where each parent could go and buy a house. And now it's like, we don't even know if one parent can be the anchor with the house, with the interest rates as they are.
It's really gotten hard for people to qualify and to give up like the interest rate they have if they have a really good one.
Oh, yeah.
It's so painful. It's really impeding settlement.
It is. And also the geographic restrictions. So, and I know this goes into process because I had a couple who did a kitchen table, and then while they were doing it, the mom was engaged to a gentleman outside of the geographic restriction. They already knew that they were going to move, but they didn't put that ISD in or that county, and so she just really doesn't have a lot of options to modify it because it's so recent. So I'd rather always to start with a good product with the information and not have to fix it, because sometimes you can't go and fix it.
Yes. Well, in the kitchen table deal, they don't understand what they're agreeing to sometimes. And then they can enter something that's wrong. And it costs more to fix it than it would have been to just hire a lawyer and do it right the first time. So we always tell people kitchen table deal is an option. Most people don't think it's a great option for all the reasons, emotional and financial, that we just talked about. But I tell them it's the least expensive way to get divorced from an attorney's fees perspective.
Oh, yes.
But it might be the most expensive way to get divorced if you strike a bad deal for yourself.
Well, and also there can be delays because they don't know what document they're going to file. So I've had people come, with an agreement, and then they'll have like a notarized affidavit. They've just made it up, and they'll say, well, I want you to file this with the court and we're done. I'm like, well, one of you needs to be the petitioner,
It doesn't work that way. We're back to that. Doesn't work that way.
And we're not in a binding agreement. So literally, and this has happened so many times, you could just rip it up because it's not enforceable as an informal settlement agreement or a mediated settlement agreement that are both defined by the law as binding irrevocable. And so those two terms are very important because I always say there's no takesies, backsies. And that's a good thing when you want it to be solidified.
Yeah.
Because when you think that you've solved all the world's problems and then you come to an attorney and they say, it's not really enforceable, that can cause some consternation.
Yes. It's challenging because we do want them to try to agree on some things, like, hey, if you all can work out the division of your furniture and we don't have to fight about that at our hourly rates, that would be great. But sometimes they can't even do that. And if they have any conversation early on before the lawyers are involved and somebody agrees to something and then they learn more about the whole situation and they back out of that agreement, we hear about that the whole case. She agreed, he agreed, They agreed. Get them back. I know that they'll agree.
That's a big problem. So as soon as someone retains me, my first advice is, if there is a proposal or someone says, hey, will you promise to always take care of me, like spousal maintenance, or always take care of our kids? Well, let's define those terms, right? But let's not. So I always say, it's like brainstorming. You just say, great idea. We'll talk about that later.
I'll consider it.
Yes. That's an interesting option.
Mm-hmm.
So because you don't want to shut them down, and you also don't want to say my lawyer won't let me agree to anything.
I was in mediation yesterday as the mediator, and one side kept saying, I have a recording of him agreeing. He agreed. He agreed, he agreed, he agreed to whatever. And then she played me the recording. Well, he did agree, and then he said, but, like, I agree, I owe you this, but I will then offset it against what you owe me. So she was only remembering the part that benefited her, right?
That's human nature. I only agree on I remember the good things, right?
Exactly.
But yeah, I've had clients bring like a piece of paper, like tiny little scribble,
on the napkin. They
and
wrote
it's
on
like,
the napkin.
I will take care of you for life. And I'm like, okay, so when you went down the aisle and you said I do, and sickness and health, we're obviously breaking that promise, right?
Yes.
And,
yes.
And I don't take that lightly, but I'm just saying all bets are off pretty much.
We don't have a deal till it's signed in a binding way.
Yes.
Or the judge signs it.
And even at that, I have to explain to clients, I've been to so many motions for clarification after a bench trial because our judges are really busy and, they're drafting memo rulings sometimes, they're not ruling the day of. And so we're not sitting there understanding, having the ability to process and ask questions of the judge. Well, what did you mean by half of this? Or so, and those can cause attenuated, longer litigation post-divorce, and the client's just like, I thought I was divorced. I mean, you told me we were going to trial and it was going to be over that day, but now we're going for clarification on what, this asset is no longer part of the estate. I sold the car broke, I got into an accident. So how do we offset that spreadsheet? And yeah, that's been kind of a recent trend I've seen with the memo rulings.
And especially if there's a big delay, because every day things change, right? Like
Yes.
you said, property gets spent, broken. The children's situation changes every day. So it's live action. And if they don't rule quickly, too much has changed by the time they rule.
We have a case right now where there was a delay of 7 months in
my
ruling
word.
on a modification. And that 7 months almost cost a teenager their life. And right now we're back in the court litigating after we had a full trial, because things change, to your point, and especially those crazy teenagers. I have two of them, and they're always kind of changing their minds, and also just this culture we live in is very, I think it empowers teenagers to make choices. And that can be good, but then also these parents who are like, hey, talk to the judge. We want you to say this. And as you know, that is never, I don't think, that's my last go-to in litigation in this process.
Well, 7 months to rule, that's horrible. Yet another reason that either collaborative or using mediation and litigation is a better choice. The statistics show that people who settle, meaning they have agreed to the deal, that it's much more long lasting, and they're much less likely to have to come back to court to modify or clarify or enforce or do anything, because they have said yes to this.
But they have ownership, and so
Yes.
they've had the ability to mold it and have their agency involved. I think when you go to court, sometimes you feel like it happened to you. It's a passive thing, and a lot of people feel victimized. And if you ask both parties after a ruling, neither one looks super happy. And,
Oh, agreed.
and even when I've gotten a hands down, I've gotten everything on the list, check, check, check. The client is just like exhausted.
The judge is not limited by what either side asked for either. So I had a case once where no one asked for this. Her result was, this isn't a current sitting judge. She gave one person the right to make all decisions about extracurricular, and the other person had to take them to that extracurricular, whether it was their day or not, and gave the other person the right to make all decisions about church activity, and the other person was ordered to take the child to all church activities. No one asked for any of that. So I couldn't figure out, like, did the judge get confused about which case it was, or was she trying to force settlement because she did something so horrible that no one would like it and it would require them to then come up with a new solution? But that's what can happen in court. So that's a reason to consider a settlement option.
Absolutely. Also with custody arrangements, I've had a judge do something similar where they've divided children. So
Oh my goodness.
mom gets the two eldest and dad gets the youngest. And then you have this division in the family, and I don't see how that's good for anyone.
I don't think, unless the children were hurting each other, like that was the issue, I don't think any of the research supports dividing siblings. I think the mental health community would say you should not divide siblings.
I would almost say 100%.
Yeah.
You shouldn't, unless there is abuse or, bullying or something.
Yeah, something dramatic, right? Oh my word. So, our judges, we have some good ones and some bad ones, and they have different experience levels themselves, but most of them did not own complex property and own a bunch of businesses that are owned by family limited partnerships. And so they've just had to learn on the bench, about that, and the lawyers have to educate them when we're trying to award and divide those things. But there's limitations in the law what the judge can do. They can't just make everybody sell every business or sell a partnership, there's limitations in what the judge has the ability to do. So when people have really complex property, they are much better served working together to figure out a way to not disrupt all of that business and do something that makes sense, that gets everybody some value, but doesn't just tear it all down.
Absolutely. We're going to a 5-day jury trial in a case with 10 different businesses. They're all unrelated, random, but all family-owned, closely held family-owned businesses. And at the beginning of the case, the court sua sponte just gives okay, you're going to manage this business, but the building it's in, the husband gets to manage the building. And it was just, it's so fractured, and we're going to have to educate a jury on all these issues. And at times, I don't even know if, because there's so many components, I don't know. We need charts.
Yes, lots of charts.
Charts and pictures, and this person goes here, and
Yes.
here's the shares. So that's going to be interesting.
Why would someone pick a jury? It's unusual. You do more jury work than most people, I would say. Why would someone pick a jury instead of a judge to decide?
That's a good question. Sometimes it's happened where I walk in the courtroom with my client. There's something that the judge, we can tell. Judge is not loving the client and just reacts. Or they had a prior counsel that, didn't follow the rules or did something a little underhanded, and then they get, associated by, guilt by association. So in this case, the court does not like a client in most of the cases that we go to a jury. And so we make them, human, and we tell their story. And with 5 days, you have a long time to say, this is what led up to this. This is not just, a 20 minutes aside or 2 hours aside thing. This is their life story. And in some of these cases, we have 35, 40-year marriages where they've built empires.
Yes.
And it's very hurtful because there's so much history and so much complexity there.
And the jury doesn't get to decide everything.
No.
Right? So there's certain questions they get to decide and certain things that still the judge decides.
Exactly.
Give us some examples of that.
So a jury cannot decide the possession schedule. So a lot of people are like, I'm going to tell this jury what I need to, how often my kids need to see me. Like, that's not going to happen. So they can decide geographic restriction. And so, and that can be really huge in a relocation case. Where
So a move case, somebody wants to move to
Yes.
Florida.
I just found my new love online, and I want to move to Tallahassee. And so that would be a jury question. Another jury question is disproportionate share. And so when there's fault grounds like adultery or fraud, some cruelty, then we present that, and then they can say, okay, we're going to move the needle from 50% to a different percentage. But the valuation on paper is allowed, but I don't like submitting valuation to the jury because it's such a complex issue.
Yes. Oh, my word. Well, this has been a very interesting conversation about process choices. What would you recommend to people if they're trying to sort it out? What should they do to learn a little bit more about all these processes so they could make a good choice for themselves if they were contemplating divorce?
So I think number one, just researching attorneys and seeing whose message do you like, and then talking to friends about people that they've used to get personal referrals. But as a good resource for Collaborative Divorce Texas is a website that's amazing. It's very client focused. And as for finding attorneys, if you're in Collin County, get a Collin County lawyer. If you're in Dallas, I'd say local counsel is really key. I see a lot of missteps with that, and sometimes just knowing your audience is the best choice. But getting the most amount of information, and even if it's a few consults, like even if it's 2 or 3, you're educating yourself and you're investing in the process and in what your choice is going to be, and I think you'll be happier.
Yeah, it's important. Hiring the lawyer is important. That there's good lawyers, there's bad lawyers, there's lawyers who really have the family's interest at heart, which I know you do, but there's some people who are just greedy lawyers, and they're not putting the family first. So it's something they should research and really look into.
Absolutely. And I will never, I live in a glass house. I will never disparage another attorney, but if I see a signature block on a petition that comes in a consult and it's a churn and burn fees firm, I will just say, hey, I just need you to know that, your money is not going to go as far on this one.
It's going to be more expensive when you have certain lawyers on the other side.
Yes.
That is the truth. We all know because we see their work all the day, all the time. The good and the bad and the ugly. Natalie, we are going to put your information on the screen so our viewers can find you. Where is your office?
So our office is in Allen. We're off of McDermott, 20 minutes from the Collin County Courthouse, but we practice in Collin, Denton, Dallas, and then in special cases outside counties if it's a complex case.
Yeah, same here. We'll drive about 2 hours away usually.
Yes. No private jets. No, thank you.
Oh, it's been a pleasure to have you here. Thank you so much for joining us.
Thank you.
So now the tip for the day. There's many different ways to get divorced. You could do a kitchen table deal. You could litigate. You could collaborate. You could mediate in the collaboration model or the litigation model. And it's important to understand about this when you're looking into divorce. Take the time to do the research. Look at Collaborative Divorce Texas to learn more about collaborative. There's some great resources online to learn about comparisons of these processes, and then interview more than one lawyer and ask them about all those processes, and then trust your gut. And that is the tip for the day.